Lesson: United Nations Convention on Contracts for International Sale of Goods, CISG. The United Nations Convention on Contracts for the International Sale of Goods is a pivotal instrument in international trade law, offering a uniform framework for the sale of goods across borders. It serves as an essential tool for businesses engaging in international commerce, aiming to provide certainty and reduce transaction costs by harmonizing the legal standards governing international sales contracts. Understanding and effectively applying the CISG can significantly enhance the proficiency of professionals involved in drafting and negotiating international contracts. The CISG applies to contracts of sale of goods between parties whose places of business are in different contracting states, or when the rules of private international law lead to the application of the law of a contracting state. One of the most critical insights for practitioners is recognizing when the CISG is applicable, as it takes precedence over national laws in these circumstances. Professionals must be adept at identifying transactions that fall under the CISG's purview and those that might be excluded due to the nature of goods or specific contractual terms. A practical tool for applying the CISG is the use of a checklist to determine its applicability. This checklist should include questions about the parties' places of business, the nature of the goods, and any explicit exclusions agreed upon in the contract. For instance, if the sale involves ships, aircraft, or electricity, the CISG does not apply. Similarly, contracts with a predominant labor component may fall outside its scope. By systematically addressing these factors, professionals can ensure that the CISG is correctly applied, avoiding potential legal disputes. Another essential aspect of the CISG is its provisions on contract formation. Unlike some national systems that require a formal written contract, the CISG allows for contracts to be concluded without formalities, even through conduct indicating agreement. This flexibility can be advantageous in international settings where business practices vary. However, it also necessitates a clear understanding of what constitutes an offer and acceptance under the CISG. For instance, an offer must be sufficiently definite and indicate the intention of the offeror to be bound in case of acceptance. Acceptance, on the other hand, must be a clear indication of assent to the offer's terms. In practice, professionals can use a structured approach to draft and analyze communications between parties to ascertain whether there is a meeting of the minds. This includes examining emails, purchase orders, and other communications for elements of offer and acceptance. A real-world example is the case of Philanto S.p.A. v. Chilewich International Corp., where the court examined the parties' correspondence to determine the existence of a contract under the CISG. This case highlights the importance of clarity and precision in communication when operating under the CISG framework. The CISG also provides comprehensive rules on the obligations of buyers and sellers, addressing issues such as delivery, payment, and the conformity of goods. For sellers, the primary obligation is to deliver goods that conform to the contract in terms of quantity, quality, and description. Buyers, in turn, must pay the price and take delivery as agreed. A practical framework for ensuring compliance with these obligations is the use of detailed contract specifications and quality assurance processes. By clearly defining the contract terms and implementing robust inspection and testing procedures, parties can minimize disputes related to non-conforming goods. Moreover, the CISG addresses remedies for breach of contract, offering a balanced approach that considers the interests of both parties. Remedies include the right to require performance, claim damages, or avoid the contract under certain conditions. A step-by-step approach to handling breaches involves first assessing the nature and severity of the breach, then determining the most appropriate remedy based on the circumstances. For instance, if the goods delivered are non-conforming but usable, the buyer might choose to claim a reduction in price rather than avoid the contract altogether. An illustrative case is the German Supreme Court's decision in the Mussels case, where the court applied the CISG to determine the buyer's right to avoid the contract due to the delivery of non-conforming goods. This case underscores the importance of understanding the CISG's remedial provisions and their practical application in resolving disputes. One of the challenges in applying the CISG is the potential for varying interpretations by different jurisdictions. Although the CISG aims for uniformity, courts in different countries may interpret its provisions differently. This necessitates a careful analysis of case law and scholarly commentary to anticipate how specific issues might be resolved. Utilizing online databases and legal research tools can aid professionals in accessing relevant case law and commentary, ensuring informed decision-making. Additionally, the CISG allows parties to expressly exclude its application or modify its provisions. This flexibility can be advantageous in tailoring contracts to specific needs, but it requires a clear understanding of the implications of such exclusions or modifications. Professionals should engage in thorough contract negotiations and draft explicit clauses to reflect the parties' intentions regarding the CISG's application. A practical tool here is the use of model contract clauses that specify the extent to which the CISG governs the contract, based on the parties' preferences. The importance of cultural considerations in international contracts cannot be overstated. The CISG facilitates cross-cultural transactions by providing a neutral legal framework, but professionals must also be sensitive to cultural differences in negotiation and contract performance. Developing cultural competence and employing strategies such as hiring local consultants or conducting cultural training can enhance the effectiveness of contract negotiations and execution. Statistics on the CISG's adoption and usage further emphasize its significance in international trade. As of 2023, the CISG has been adopted by 94 countries, representing a substantial proportion of global trade. This widespread adoption highlights the CISG's role as a critical tool for international commerce, underscoring the importance of proficiency in its application for professionals in the field. In summary, the CISG is an essential framework for international sales contracts, offering uniformity and predictability in cross-border transactions. By understanding its applicability, contract formation rules, obligations, remedies, and the potential for exclusion or modification, professionals can effectively navigate the complexities of international contract law. Practical tools such as applicability checklists, structured communication analysis, detailed contract specifications, and model clauses are invaluable in applying the CISG to real-world scenarios. As the global economy continues to integrate, expertise in the CISG will remain a vital asset for professionals engaged in international trade and commerce.